Dear friends, in this video, I'm going to discuss a few aspects of medico-legal nuances in the ICU. And this is important because many a times we feel embroiled situations where we tend to think that probably little medico-legal knowledge is helpful. And what are the existing laws? What are our defenses in cases of medical negligence? These also we need to know during our professional practice. Let us start with this case. A young male was admitted with fever, jaundice, and mild hypotension. The resident doctor calculates the right IGV to administer fluids and antibiotics. The patient develops pneumothorax, which gets unnoticed or undetected, and finally gets detected next day morning when consulted during the routine rounds. There is a suspicion and which is confirmed by the chest x-ray. 2 days later, this pneumothorax worsens, requiring ICD insertion. And 4 days later, the patient develops pneumonia, which requires elective ventilation. Finally, after 10 days, the patient dies. So the patient's relatives file complaint of medical negligence against the doctor. Now, what are the applicable laws of Bharatiya Nyaya Sanhita, that is our current the medical of the current legal system in our country in such cases of medical negligence? If you go by the rule by the sections, then the section 106 of the BNS actually describes causing death by negligence, and under this there are two sub clauses, 1 and 2. In 1, it is said that whosoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with an imprisonment of either a description for a term which may extend to 5 years and shall also be liable to fine. And if such an act is done by a registered medical practitioner while performing a medical procedure, then that quantum has been reduced from 5 years to 2 years, but they will also be liable to fine. Now, this is something which has the BNS, the Bharatiya Nyaya Sanhita has given a relief to the doctors in that, which in standard cases is a term of 5 years, the quantum has been reduced to 2 years. The second part is also under section 106, but that deals with rash and negligent driving of a vehicle, but that is not for our concern. Now, obviously, the question is that how different is this if we try to compare it with the earlier section of 304A of IPC that was invoked till recently. Now, section 106 of this BNS classifies this two under two clauses, 1 and 2, or both are cognizable, but the difference is that one is bailable. So the one of negligible medical negligence is also available, triable by magistrate of the first class, and the quantum is 2 years of imprisonment and fine, in contrast to all other cases where it is fine plus imprisonment for 5 years. That cause the death which is caused by rash and negligent driving of vehicle is non-bailable. Now, it is to be point to which has to be noted is that under section 304A of the IPC, which was analogous to the section 106 of the BNS, the court had discretion to impose only a fine instead of imprisonment. But that has been removed from the BNS. So under BNS, it is mandatory. Fine is no longer alternative, but it is mandatory with the sentence of imprisonment that extends up to 2 years. So if it is proven in the court of law that there was definite negligence, then one has to be prepared to pay fine in addition of undergoing imprisonment that may extend to up to 2 years. The amended law has significant consequences for the investigation and launch of criminal prosecution for medical negligence in that case. Now, another important aspect which needs to be understood, especially for intensivists, because we are dealing with more sick patients, more critical patients at odd times, that how does this Bharatiya Nyaya Samhita affect the applicability of preliminary inquiry? Preliminary inquiry is something which the court can note before before looking deeply into the case, or before an FIR is registered, a preliminary inquiry was expected. Now, this is a procedural safeguard applicable to medical negligence cases, And this flows from the Supreme Court judgment in Jacob Bethu versus State of Punjab, and was subsequently upheld in Lalita Kumari versus State of UP, that prior to the launch of investigation and registration of an FIR pertaining to medical negligence, the purpose of preliminary inquiry was to ascertain whether the information received reveals any cognizable offense. So now this was also an invisible safeguard for the doctor, because the Criminal Procedure Code of CRPC 1973 did not contain any express provision outlining the contours of this preliminary inquiry. And if at any point of time the court felt that there is no cognizable offense, it is not a cognizable offense, and the preliminary inquiry reveals that there is not enough material into this case, it would have been dismissed without the doctor needed to do anything. Now, if you see this, what has changed now? If you see that under the sections 1733 of the BNS, preliminary inquiry may be conducted where the information pertains to cognizable offenses which are punishable for 3 to 7 years to ascertain whether there exists a prima facie case for proceeding. Now, as has been seen that for the registered medical practitioners, the quantum has been reduced from 5 years to 2 years. So the preliminary inquiry does not apply for medical practitioners anymore. So cases involving medical negligence resulting in the death of a person, they're ineligible, because here the maximum term is up to 2 years. So as against 3 to 7 years. So where a complaint was made to a magistrate previously under section 304A of the IPC, the onus was on the complainant to satisfy the court with the existence of prima facie case, and if it was found lacking in basis, or if it was found to be frivolous, the court would dismiss the complaint. So in fact, without having to do anything from the doctor's side, the case would have got dismissed. Under BNS, though the complaint may ultimately be dismissed, but the accused doctor will still have to undergo the hassle of being present in the court and presenting their version of the events. So this is an extra responsibility, or an extra task on the doctors to be able to defend themselves, that flows from the Bharatiya Nyaya Sanhita. Now, another important provision which deal with this section of BNS deals is the provision of deemed sanction. Deemed sanction was something which was not there in the earlier laws, that to prosecute a public servant for an act performed during the discharge of their official duty, previous sanction of the relevant government was mandatory. It's like if doctor happens to be in a government medical college or in a government hospital, in case there is a medical negligence, then in order to prosecute that public servant, the doctor so-called who has been accused, then a relevant sanction was necessary from the government. So it was the prerogative of the government to grant or refuse sanction. It is still the prerogative of the government. And this gives an impression that this enables the public servants to discharge their duty fearlessly without bothering about the consequences of frivolous litigation. Now, this concept of deemed sanction ensures that if government takes no action, if the government does not gives any decision within a stipulated period of 120 days, then it will be accepted that the government has given sanction, this seems to be granted. So it is a kind of an opt-in has been taken in the Bharatiya Nyaya Sanhita, so that it becomes a job for the doctor now to see that government rights in such cases pertaining to medical negligence in government institutes and government medical colleges, that rights to refuses to grant sanction in such cases where the case is frivolous. Otherwise, if government doesn't respond, then it will be taken to as a it will satisfy that the government has sanctioned this. So what are the sanctions in BNS which are available for the defense of doctors? So going by this, after knowing this hindrances, it is important to know how we can defend ourselves when we face such medical negligence issues. Now, section 18, this is one section which says that nothing is an offense if it is done accidentally, without criminal intention, and with proper care and caution. So this is something which comes in favor of the doctors. One has to establish with facts of the case that proper care and caution were exercised. Section 19. Nothing is an offense even with the knowledge that it is likely to cause harm if done without criminal intention and in good faith to prevent or avoid other harm to the person. So now this is something also we know that which can apply to minor forms of surgical procedures, drainage procedures, which have procedural complications in the ICUs or emergency situations that can come in for defense of the doctors. Section 26, an act is not considered an offense if it is not intended to cause death, is done in good faith, and is carried out with the consent of the individual. So again, it becomes easy for the doctor if he has taken necessary precautions to, to defend himself under section 26. If none of these sections are applicable and is really in a bad situation, the accused physician, then he can take recourse to section 30. An action is not considered an offense if it is not intended to cause death, is done in good faith, and is carried out without the consent of the individual, provided that person is incapable of giving consent. So if the person is comatose, if there are no attendants available and the procedure is an emergency procedure, so in all such cases, if some complications happen at the time of the procedure, then section 30 becomes useful as a defense for the doctors. The next important medical legal issue for critical care physicians is now the algorithm is now the practice of this algorithm which has flown after the judgment from the Supreme Court on withdrawal of life-sustaining treatment for patients without an advanced directive. We all know that in our country, advanced directive is a rarity. It is a rarest of the rare. We come across a patient who has written in full consciousness about what he intends to have done to him in case he is incapacitated, in case such procedures need to be performed. Now, treating physician informs the hospital about the terminal nature of the illness without any hope or cure, and the hospital has to constitute a primary board. And this primary board discusses prognosis, pros and cons when withdrawal with the family physician, patient's next kin or next friend or guardian, communication, consent in writing. So everything preliminary opinion is given within first 48 hours. Now, this is one primary medical board. Next, for withdrawal, a secondary medical board visits the patient, concurs with the primary board, and the hospital intimates the judicial magistrate first class and the patient relatives or the proxy within 48 hours. So 48, 48, 96. In case there is any disagreement between these two primary boards, primary and the secondary boards, either the primary board refuses or the secondary board does not concur, the nominee of the patient may move to the High Court to withdraw life support by way of writ petition under Article 226 of the Indian Constitution. Now, it is important for an intensivist to know that what should be the composition of the boards. So the primary board composition says that the treating physician and at least two subject experts of the concerned specialty with at least 5 years of experience. Now, previously, 20-year experience was required from the specified specialties, but now, as per this new algorithm, it is 5 years. In secondary board, one registered medical practitioner nominated by the CMO of the district and at least two subject experts with at least 5 years experience of the concerned specialty who were not part of the primary board. Now, this is the composition of the primary and the secondary board that needs to ratify the withdrawal of life in succession, first 48 hours followed by another 48 hours. Now, what process of documentation should be followed in such cases? This is also a very important matter because there are a lot of variations in practice from ICU to ICU, from state to state. And many times we get away minor with minor mistakes on the assumption that this go unnoticed, but we have to know that hospitals must receive the proposal for withdrawal of care from the treating physicians in a documented standard of care format. Now, this standard of care format can vary, but it should contain essentially all the points which the primary board and the secondary board has observed. Documentation of all withdrawal of care must be transparent and meticulous, both by the treating physician and the hospital. Both digital formats and hard copies of the withdrawal of life support decisions are to be kept by the registry of the High Court, which shall be destroyed after 3 years from the death of the patient. Now, this is an example of safeguard suggested by concurring decision of the Honorable Justice Sikri in 2018 judgment. So this was the beginning of the end of life practice in India, in which this 3 years was defined or was earmarked. Now, what has been the key reforms which have been undertaken by the Ministry of Health and Welfare, Family Welfare in 2024 regarding organ donation? Because this is also another crux issue in which in which the intensivists have a big role to play. Now, we have to know certain points that authorization committees must process applications within 10 days. Now, timelines have been framed. Decision timelines are capped at 6 to 8 weeks. Aadhaar verification is mandated for donors and recipients. Swap transplants between foreign pairs and Indian pairs are disallowed. Any appeal under Rule 33 of the Act, that is the THOTA Act, Transplantation of Human Organs. So, and the decision of the authorizing committee would have to be decided within a maximum of 30 days. And donation from a minor living donor shall not be considered without the prior approval of the appropriate authority and the state government concerned. Now, what more important for intensivists is that what can constitute or constitute to illegal activities and penalties for brain death and subsequent organ removal. One needs to be very cautious and adopt a legally correct approach. One has to know that the section 19 deals with unauthorized organ removal, punishable by an imprisonment up to 10 years and fines up to 20 lakhs. And the registered medical practitioner may face deregistration for repeated offenses. Commercial organ trade under section 18, transactions involving payment for organs attract imprisonment and hefty fines. And illegal tissue transactions under section 18A, that also applies for similar penalties for which apply for trafficking in human tissues. Now, what are, as per the THOTA Act, who as per the are allowed to give consent for organ donation after death of the patient? The donor's own authorization, if it was done before death, in presence of two witnesses, is adequate unless the next of kin has a reason to believe that it was subsequently revoked. Now, that leaves aside a big gap, and we need to wonder in the future at how to seal that gap, because a lot of issues can creep in on the basis of this clause. Second is that final authorization for organ donation after brain death may be given by the patient's next of the kin. In cases of minors, authorization may be given by the parents. And in case of unclaimed bodies 48 hours after death, if it still remains unclaimed, the person in charge of the hospital or person in lawful possession of the body may give authorization for the organ donation. One thing we have to remember, that removal of eyes from a dead body of a donor is not governed by such an authority and can be done at other premises and does not require any licensing procedure. So my key takeaways in this subject would be that medical legal issues in the ICU often revolve around patient autonomy. We need to understand that end of life care and potential negligence, which may have is aspects of informed consent, withholding or withdrawing life support, surrogate decision making for incapacitated patients, medical errors, hospital acquired infections, as well as poor communication. And always the best practices to mitigate such risk are through open and honest communication, thorough documentation, adherence to protocols, and professional collaboration with other experts. Thank you.